Hey everyone, so I did say in my video earlier today that I would be covering this update in the New York Times against Wayfarer case, the New York State case. So where we were last time I covered this particular case was Wayfarer had filed their opposition basically to the New York Times motion for summary judgment, and they had filed a cross motion to stay the case. So where we are now is, this is the New York Times. They have replied to Wayfarer's opposition to their motion for summary judgment, and they are going to oppose Wayfarer's cross motion to stay. So it's quite a short document actually, so we should not be here long. I think it's about 10 pages. Okay. Plaintiff, New York Times, respectfully submits this combined memorandum of law. 1. Replying in further support of its motion for summary judgment. And 2. Responding in opposition to defendant Wayfarer Studios' cross motion to stay. So there we are. Argument. Unable to respond substantively to the Times motion for summary judgment, Wayfarer instead seeks to delay the resolution of this straightforward anti-SLAPP case. It does so by asking this court to stay the case until a hypothetical appeal in its sprawling federal lawsuit concludes. What Wayfarer does not do, despite taking more than 6 weeks to draft its opposition papers, is address even in the alternative, the arguments in the Times' motion, a failure that this court should treat as a forfeiture. In any event, Wayfarer's arguments for a stay fall flat. A stay is a departure from the ordinary course of litigation and a matter of judicial discretion. But Wayfarer has failed to show good reason for the court to exercise that discretion here. A stay would severely prejudice the Times, barring it from recouping its substantial legal costs, while a not yet filed appeal involving multiple unrelated claims and parties runs its course. And Wayfarer has failed to show that waiting would yield a different outcome, since the federal court's decision makes clear that dismissing Wayfarer's baseless claims against the Times was an easy call, an appeal, if one is ever filed, would be meritless. Finally, Wayfarer's behaviour indicates that its request is a stall tactic meant to delay this case, an outcome that would frustrate the purpose of the anti-SLAPP law. The court should reject this dilatory conduct, deny Wayfarer's cross motion to stay, and grant the Times' motion for summary judgment. Okay. I get the sense that they were a bit irritated. By failing to respond substantively to the Times' motion for summary judgment, Wayfarer has forfeited any arguments in opposition to that motion. As a threshold matter, Wayfarer has forfeited any arguments in opposition to the Times' motion for summary judgment. New York courts routinely conclude that a party concedes a legal issue by failing to address it in opposition papers. Okay. That is exactly what Wayfarer did here. Wayfarer's bare assertion that it reserves the right to substantively oppose the motion at some later point does not save it. Its opportunity to do so has already passed. The Times consented to a briefing schedule that gave Wayfarer a month and a half to prepare its response to the motion for summary judgment. Wayfarer had until February 27, 2026, to respond to a motion submitted on January 14, 2026. Instead of presenting that response, even as an argument in the alternative, Wayfarer says nothing at all. The Times' motion for summary judgment should be granted for that reason alone, along with other reasons identified in this opening brief. Wayfarer has failed to justify a stay of this case. Wayfarer seeks to excuse its failure to respond by asking the court to stay the case pending a hypothetical appeal that it intends to file in the federal lawsuit. But it admits the determination as to whether to grant a stay rests within the court's discretion. When exercising that discretion, New York courts recognize that a stay can easily be a drastic remedy on the simple basis that justice delayed is justice denied, and that the party seeking one must show some excellent reason to justify this departure from the ordinary course of litigation. The court should decline to grant the requested stay for 3 reasons. First, a stay would prejudice the Times by tying this case, and by extension its recovery of more than $181,000 in fees, to the conclusion of a prospective appeal that is, at best, months and more likely years away. Wayfarer's federal lawsuit is a complex, sprawling case in which the Times was an ancillary participant. More like a co-conspirator, but, semantics. The amended federal complaint naming the Times as a defendant ran 224 pages and involved 12 other parties. But as Wayfarer explains, the case primarily arises out of a dispute between actress Blake Lively on the one hand and Wayfarer on the other. The Times was added belatedly in the amended complaint. I don't like the framing of that. They know fine well that they were actually sued first. Wayfarer initiated a lawsuit against the New York Times first before they sued Blake Lively. It was just in California, and they, agreed with Judge Lyman that seeing as Lively had filed in New York, they would just consolidate the case to New York instead of having 2 opposing cases on, opposite ends of America, basically. It's just... So, yeah, they were added late to the amended complaint, which involved Blake Lively, but they were actually sued before Blake Lively. So this is disingenuous, as usual. The Times was added belatedly in the amended complaint, and because the claims against it were so weak, was able to extricate itself quickly while much of the lawsuit continues. But the federal court has determined that Wayfarer can wait until a fee dispute with one of the other parties, Ms. Lively, concludes before deciding whether to appeal the dismissal of the claims against the Times. Even when that happens, and even if Wayfarer elects to pursue an appeal, the appellate process takes time to run its course. I mean, it's not much of an argument, really. That's a shit argument, actually, to say, well, yeah, but the appellate process, it takes a long time, and, but just for that reason alone, you should just give us, our summary judgment. That's not a reason to be granted motion for summary judgment. In these ways, this case is meaningfully different from the cases Wayfarer cites when an appeal is already ongoing, or where the parties to the disputes were substantially the same. Here, instead, Wayfarer asks the court to wait for an allegedly forthcoming appeal, likely involving parties and legal issues unrelated to the claims against the Times. Cases imposing stays pending a federal district judge's decision are similarly inapplicable if that is the relief Wayfarer seeks. Its request is already moot. It is also misleading for Wayfarer to cite the Times' decision not to respond to the federal court's order to show cause and the federal court's discussion of prejudice in its subsequent order entering judgment to suggest that a stay of this case would not prejudice the Times. As the federal court observed, the Times has no ongoing obligations in the federal case. The claims against it have been dismissed, and unless and until the Second Circuit reverses the district court, it does not have to litigate against anything. The prejudice that the Times identified in a delayed resolution there was that if the Second Circuit reversed and the case proceeded to discovery, that discovery would be harder to complete due to the passage of time. A stay in this case, by contrast, would prejudice the Times in a different and far more serious way, preventing it from recouping its significant legal fees while disputes among other unrelated parties play out. Second, even if Wayfarer does eventually appeal, the federal court's disposition of the claims against the Times, such an appeal would be meritless. As the Times has explained, dismissal here was not a close call. The federal court was so certain that the defects in Wayfarer's claims against the Times could not be fixed that it denied leave to amend them, calling one of those claims meritless in any formulation. For this reason, the risk of inconsistent rulings is exceedingly low. Wayfarer does nothing to disturb this conclusion, never bothering to explain why it expects to succeed on appeal beyond a rote summary of the basis on which it could challenge the federal court's decision. Third, Wayfarer's litigation conduct suggests that the purpose of its stay motion is to delay the resolution of this straightforward claim. New York courts have held that stays should be rejected when they are designed to delay proceedings for some kind of tactical advantage. These concerns are particularly acute in anti-SLAPP cases, since the statute aims to protect free expression by allowing parties targeted by SLAPP suits to quickly resolve the suits and recover their attorney's fees. In this case, the federal court has already highlighted Wayfarer's dilatory conduct meant to extend the litigation. This is a common tack in SLAPP suits, where prolonging a resolution can run up costs for the targeted speaker before it has a chance to recoup them. And tellingly, Wayfarer has not sought to stay the two fully briefed fees motions, one brought by Ms. Lively and the other by Leslie Sloan, in federal court, even though it could still appeal the underlying dismissal. It even argues in response to one of those motions that federal court is the wrong forum for claims under the anti-SLAPP, precisely the dispute the Times sought to avoid by bringing this case here. The most plausible interpretation of this behavior is that Wayfarer is using the still open federal appeal window as an excuse to halt this case while pressing forward on the other fee disputes in which it believes it has stronger arguments. But Wayfarer cannot have it both ways, and the court should not reward these tactics for the stay. Okay, conclusion. For the foregoing reasons, the Times respectfully requests that the court deny Wayfarer's cross motion to stay, grant the Times motion for summary judgment, award the Times its reasonable attorney's fees in the amount of $181,622.70, and provide such further relief as the court deems appropriate. Okay, some interesting arguments. Not unreasonable ones, actually. I mean, Wayfarer indicated they may appeal. That window is open. That does not mean they will appeal. And, it's not unheard of for for parties to kind of cite a possible future appeal to delay these kind of cases. So I think the Times actually have written a fairly decent response for the purposes of what they're seeking to do. I wonder, Wayfarer should get a reply to this, because obviously, this is, whilst it's the reply brief, which then fully briefs the motion for summary judgment, their cross motion, this is the opposition. So I believe Wayfarer get to reply to the opposition part of the cross motion. I would assume so. I'm not entirely sure, but I will keep a lookout for it. But yeah, so there we go. That's the response from the New York Times. We'll see what we get next, whether it's from Wayfarer or from the judge.